Okay, well, it is time to get started. Thank you for everyone tuning in for our fourth session for our day of CLE, Continuing Legal Education Training from the Military Law Task Force, the National Lawyers Guild. We're excited for everyone joining in online, our folks attending in person, and then, of course, folks watching recordings later. So we're really happy to have you here today. We have today for our presenters, we have two of us here in person, myself and Aaron Frishberg. And let me tell you a little bit about both of us real quick for those joining us. I'm a civilian attorney that practices in military law. I've been doing it since 2006. I'm part of the steering committee for the MLTF and a past chair. And I'm the author of the book, U.S. Army AWOL Practice Guide and Form Book. And then Aaron, I'll read what his is. It says, Aaron Frishberg joined the Military Law Task Force over 35 years ago. I think Aaron, you're probably one of our longest standing members, probably.
Well, Kathy's been here since long before me.
Okay, so Kathy has you beat, but other than Kathy, you might be one of our top most longest members.
Well, we have David Guestpass.
David Guestpass and Kathy Johnson. So there's a few others, but again, one of our longtime, most stalwart people. And he says, well, at New York Law School, where he participated in organizing a seminar to support resistance to the Jimmy Carter draft registration initiative, a bellicose response to the Russian invasion of Afghanistan. He has relied on the support of the network of MLTF advocates and attorneys in his casework, never being fully immersed personally in any aspect of military law. He helped to organize a training on military counseling in New York, which became the foundation for a New York City chapter NLG Military Law Committee. And then our other presenters for this block who are appearing from online, we have... Sorry, I'm doing two devices here. Okay, Jonathan Hutto. Jonathan is an anti-oppression community organizer and author who has made substantial contributions within both nonprofits and grassroots organizations for over a quarter century. Jonathan embraced his calling as an undergraduate student at Howard University in the late 1990s. In 2006, as an enlisted member of the U.S. Navy, he co-founded the Appeal for Redress from the Iraq War, which was awarded the 2007 Letelier Mofi Human Rights Award from the Institute for Policy Studies. And then finally, we have Kathy Gilberd, who is the executive director of the MLTF and a legal worker focusing in the areas of military administrative law and discharge review. She serves on the board of directors of the National GI Rights Network, and she is the author with Marjorie Cohn of Rules of Disengagement, The Politics and Honor of Military Dissent, and was also a contributing author in Clark Boardman Callahan's book, Sexual Orientation in the Law. She is a frequent contributor to MLTF's quarterly journal On Watch, as well as an editor for the publication. So those are our presenters for today, and we are, sorry, got too many things in my hand. We're discussing today complaints and redress of grievances, and I'm really excited we're going to talk about this now because it really came up in some of our previous sessions, some of the concerns of circumstances where service members are mistreated. What do we do? So to start that off, and I forgot, we discussed a little bit. Does anyone remember who is going to present first for this session?
Up to you.
Well, Kathy, do you want to get us started, and then we'll go from there? Does that sound good to the presenters? Okay.
Okay. Well, and I'm going to talk specifically about military equal opportunity complaints. Earlier in the CLE, I said that GIs are told they have no rights. They're also told that they cannot make complaints, and that doing so will not only not get them anywhere, but it will also get them in trouble. It is true that intimidation and retaliation are a really big part of all the military complaint procedures, but there are also some protections there. These procedures are built into the military regulations, sometimes into statute. And what I'm not going to talk about, and hope someone else will later, is how you choose which of the different complaint procedures you want to use. I'm just going to jump into military equal opportunity, which is covered by Department of Defense Instruction 1350.02, last changed in December of 2022. It's not in our list of materials for the CLE, but it is covered in a memo on our website, Assisting Service Members with Military Equal Opportunity Complaints, that has links to the DoD instruction and to the various service regs. But I will go through them just quickly. They include Army Regulation 600-20, the Chief of Naval Operations Instruction 5354.1H, Marine Corps Order P53541F, and for the Air Force, Department of the Air Force Instruction 51-508. Military equal opportunity complaints have a bad reputation, partly for not being very effective and partly for resulting in retaliation. It's my sense that while that bad reputation is really deserved, there are things that can be done to make the complaints more effective and to prevent against or at least limit the retaliation that happens from them. Originally, MEO complaints were limited to discrimination based on race, gender, religion, ethnicity, your basic protected classes. Over time, this has expanded, although many service members aren't aware that other things are now covered by the MEO procedures, but they now include discrimination based on sexual orientation or gender identity, and they also now include specifically sexual harassment, as well as general harassment and bullying. Those last two are fairly recent additions. And again, service members tend not to know that this could be a basis for an MEO complaint. So they're not brought very often. People have, under the Department of Defense instructions, 60 days from the incident of discrimination or harassment until they must bring a complaint. And I would normally say that unless there is an emergency, they should take use of those 60 days to do some advanced preparation. Complaints are begun by going to the command's military equal opportunity professional, mostly called MEO officers, although they are not normally officers. They tend to think, as a group, that service members with a complaint should just walk into their office and let them write the complaint out or tell the service member why they shouldn't make a written complaint at all. In reality, the complaint and documentation will be best if put together well in advance of going to the MEO officer, and really do best if done with an advocate, with a counselor or attorney who can assist in putting together the claim, the documentation, and in some cases, a legal brief to go with it. That's really unheard of in MEO complaints. But normally I would suggest that before going into the MEO office to start with, that the service member with help write out their statement of what the complaint is and what remedy they want for it, that they go through and attach documentation, evidence such as emails or memos within the command that show the discrimination or harassment, that they include witness statements, and, as I said, that they think about doing a legal brief to be part of the complaint. Each of the services has a form that needs to be used to fill out to start the complaint, although limiting oneself to the brief space on the form is not going to get you a very good complaint, but it's a starting point. And I will just use the Army as an example. They have DA Form 7279, which has little spaces. but does say that you can attach an addendum if you need. Starting with that, it's useful to include all of the incidents of discrimination or harassment, noting where they are verified in the documentation or witness statements, noting, if possible, how they violate military regulations, and giving the names of individuals that should be talked to for further evidence about the discrimination or harassment. So you walk into the MEO officer's office with all of this paper, and he or she says, there are 3 ways you can make an MEO complaint. You can do it anonymously, which is a relatively new element of MEO life. You can do an informal complaint, which doesn't need all that paper at all. It doesn't have to be written. And it's handled very, very informally at a low level in the command, and it's not going to shake anybody up, and you'll probably be much happier with it. Or, in the third alternative, you can do a formal written complaint, which requires a command investigation and then review by higher authority if you want to appeal. I'll write this out for you if you want to do it. Sometimes MEO officers are really well trained and really thoughtful and want to help. And sometimes their suggestions for what should be in a complaint are very useful. Other times, they may cut the heart out of what your client wants to say in the complaint. And there is no requirement that the MEO officer be allowed to write or edit or change the complaint or any of the documentation with it. As I mentioned before, there's a 60-day period from the last harassment or discrimination. But by the way, the Marine Corps says there's 90 days. The theory is that if a service regulation takes away some benefit or right from a service member that's given in a Department of Defense instruction, the DoD controls. But if the service gives more right or benefit to the service member, then the service reg controls. So the Marines have an extra 30 days to put their case together. Sometimes clients come late in the game and the 60 or 90 days has passed. There are provisions for an extension if there's just cause, but that's also a time to think about other forms of complaint where there are not the same time limits. With an IG complaint, Inspector General complaint, for instance, I believe one can bring it within a year. There are no limits on congressional complaints. So one of the considerations there is going to be the timing. Once the MEO officer has figured out that your client is going to stick by what she has said, he or she then takes the complaint to the commanding officer. In all the services except the Air Force, the commanding officer initiates an investigation or appoints an investigating officer to look into this. In most of the services, the commanding officer also has the option of saying, there's nothing here, there's nothing to this, I'm just going to dismiss it out of hand. That's not allowed in the Army, but otherwise there is the possibility that things will stop at this point and an appeal will be necessary at this point. So in most services, the commanding officer appoints an investigating officer. In the Air Force, interestingly, it's the MEO officer who does the investigation. Usually, the investigation is supposed to happen within 30 days, but, you know, extensions are granted in a pretty relaxed way. The investigating officer is supposed to obtain legal advice and supposed to talk to the MEO officer about what all this means. And following the investigation, the investigator is supposed to talk again with the MEO officer and get a legal review from a JAG. So there are these legal and procedural guides at the beginning and end of an investigation. In my experience, what happens in the middle is often very fluffy. I've seen investigations in which the witnesses named by the complainant were never contacted. And while I don't think this one could happen today, I have seen investigations in which the complainant was never contacted by the investigator. It's possible when investigators feel closer to the command than to the complainant that they will flip the case around and start investigating the complainant to see if he or she has any skeletons in their closet or any bad reputation in the command or any misconduct that could discredit him or her and be grounds for finding that the complaint isn't substantiated. The investigator can make a recommendation on that, but the investigation goes back to the commanding officer whose job it is to decide whether or not this really has been substantiated, and if so, what remedies to grant. Both sides, both the complainant and the accused, have the right to appeal. Here's another difference between DOD and the services again. The DOD instruction says that there are 30 days to appeal. The Army and the Navy say, sorry, you have to do your appeal within 7 days. Now, it's very difficult to write a good appeal of a document that you have not yet been given because you have to request the investigation. It's difficult to do that in 30 days, let alone 7 days. So here again, it may be valuable to argue that the DOD instruction is controlling and that 30 days is the required time. On the other hand, if I were being cautious, which I normally am with the Army and the Navy, I would get something in by their 7-day deadline and note that I wish to augment it or amend it within 30 days as I'm allowed under the DOD instruction.
I like that approach a lot. Kathy, so mentioned, I like that approach a lot. And specifically putting that that I'm asking for 30 days because of the DOD instruction, putting that in writing would be very, very helpful.
Yep. One of the interesting things about the DOD instruction is that it says nothing about the contents of the appeal. On what basis can you appeal? Can you add new evidence? How long can the appeal be? It's not covered at all. But the services, each in their own way, have limits on everything from the length to whether or not you can bring in new evidence to whether or not you can really get at any new issues at all. So it's important to look at the service regs. If they don't allow for what your client wants to do, again, you can rely on the fact that the DOD leaves it entirely open. The appeal process bounces up the chain of command. It is not always the case that people make appeals. Sometimes they give up in sort of frustration. But while I don't have any statistics on the appeal process, I think that if it's done with an eye to legal issues and with note of anything that's going to be embarrassing to the command, that there is a decent chance of success. I want to talk a little bit about what to do after that. People who've been working in the area of civilian equal opportunity think, and all this is just the prelude to going to court. Unfortunately, in the military, going to court over this is the exception and not the rule. There is a further administrative appeal set. Most services have 2 or 3 levels of appeal. And I think DOD expects that there will be 3 levels, the final level being headquarters for the service, the secretary or the chief of naval operations. But I'm sorry, I'm not remembering. The Marine Corps has, I think, only one, possibly two levels of appeal. It's another place where relying on the Department of Defense instruction may get you an avenue that people normally do not have. But that's normally the end of it. These cases are very rarely litigated. For people who are thinking about that, I would suggest that they take a look at Cushing v. Tedder. I don't have the site, but there's a nice little memo on it on the Military Law Task Force website. It was not an MEO case, but one in which the court was very happy to tell the military it had to follow its rules. This whole process is not really designed for the complainant to have a lot of control, and it is designed to be intimidating to the complainant. By way of the former, lack of control, the complainant really has no way to ensure that the investigating officer will look at all of her documentation, interview all of her witnesses, and not go after her. By way of the second, the intimidation, when you submit a complaint or your client submits a complaint, they are told in writing that they will face criminal charges under the UCMJ if there are any false official statements. Now think about that. Where else in the world do you expect that somebody bringing a complaint is first going to be told, you can get in trouble for doing this if we find that there's anything false in it? It's a little worrisome. Retaliation in these cases is a reality. Excuse me, as I think Jonathan will tell us in more detail. The MEO regulations say that retaliation is not proper, but they don't go into any detail about it. And really the best place to look for challenging retaliation is through the Military Whistleblower Protection Act and the Office of the DoD or Service Inspector Generals. The basis for that is 10 USC section 1034. And in the case of retaliation, thankfully, you have a year from the time of the retaliation to submit a complaint. And thankfully now, military equal opportunity complaints are protected communications for purposes of whistleblowing. The problem is that that's a slow process. And where retaliation is affecting the life or safety of your client, it's also important to make some noise about it at the command level. Both the commanding officer and the MEO officer should provide assistance if there's retaliation, unless they're the one doing the retaliating. If necessary, I think this is a good point for the counselor or attorney to do some direct interaction with the commanding officer, or at least the commanding officer's staff judge advocate or legal officer, where there is a risk of physical harm. One can also ask for a military protective order or for a protective transfer, although these aren't built into the regulations, but a command that's under pressure from a civilian advocate and perhaps a civilian organization like Military Law Task Force or ACLU can sometimes give that kind of protection. I think that later Jonathan is also going to talk about the protection that comes from having support in the civilian world and in your command, and those are also really important things to prevent against retaliation.
Well, this is probably a good spot for us to stop for a moment, and we need to give the next code for this hour. So if you're watching this online and are seeking CLE credit, please write down this code. That code is T as in tango. T as in tango. That's the first code for this session. We'll have the second code a little bit later on. I thought right now might be a good time for us to transition a little bit, and I'm going to share a little bit about some of the broader picture of grievances and methods of redress. I have Aaron here with me. I'm going to ask him to jump in some along the way, and then we'll close our time looking. Jonathan will be sharing with us some very practical stuff of his experiences, and particularly on the redress side of things. So I want to mention that for attorneys and GI rights counselors who are working on these issues, very often the question is, there's a grievance, there's a problem. What do we do with it? There's several methods our clients might choose to take. One of those, the most basic level, is taking advantage of the command's open door policy. That is meeting with a higher level of the chain of command, actually using this policy that gets posted in the bulletin boards and largely ignored, but going ahead and having that conversation. In rare cases, that can lead to some good things. Often it does not. I won't go into the details of that here just due to time constraints, but I would mention sometimes, some situations, just having a conversation can make a difference, particularly when, say, it's an NCO who's causing problems. Sometimes the company commander would love to nip that in the bud, sometimes not. Other tools in our toolbox. UCMJ, Article 138. That is a provision of the UCMJ that allows a service member to make a complaint against a commander when they have been wronged in some way. The challenging aspect of this is the UCMJ Article 138 is very short. And because of that, you have to go to DOD and especially branch-specific regulations for how this gets executed. And one of the best examples of this is, for instance, I believe the Army requires that before you make a formal complaint under 138, you first have to make an appeal for redress to the commander or actually to the wrongdoer, basically asking them to fix this before you actually file the complaint. So because of that, there's a fair bit of strategy involved. I will say in most of my cases that have dealt with 138, normally it did not go past the initial request for redress. Normally things were resolved in some way that we did not press forward to the actual complaint, because the actual complaint goes up the chain of command to a higher level of chain of command. It can be quite embarrassing for commanders to get one of these. And so because of that, very often just the threat of not even filing the initial request for redress, but just mentioning 138 is enough to let us get a change of course. I will mention, though, if you are pursuing this, and particularly in the Army context where it requires you to first reach out to the commander first, my suggestion is fairly early on, invoke the words Article 138, appeal for redress. Invoke that early on, because there's a time limit that and I'd have to look at the regs to know for sure on that. Each branch is a little different. But the sooner you can invoke 138, then you can call that the appeal for redress, and it gets you quicker to actually file the actual complaint. Now, what are other tools? IG, Inspector General complaints. I will be upfront and say I am not very optimistic in those. I've seen them help once or twice. I've seen them hurt more than help. So I'm pretty leery about IG complaints, but there are circumstances where it can be useful. As Kathy mentioned, of course, the MEO process of complaints to that system is there. There's also, I'll mention another one, and this is, I think Jonathan will touch on this too. It is involving pressure from Congress. And sometimes that might be just through writing a member of Congress a letter, or it might be something more formal. Ask whether the member of Congress writes a letter to your command, which is called a congressional inquiry. And by law, the command has to respond to the member of Congress. That's the good news. The bad news, what does the command usually say in those letters? Don't look here, nothing to see, everything's fine, and most members of Congress just move on. And so what you need to be ready is to tell the member of Congress you're working with, say, look, we're expecting you to get blown off. Please keep pushing, because that's what makes the difference. But again, sometimes congressional inquiry, the best thing about a congressional inquiry is just threatening it. Just mentioning, I don't want to have to involve my client's congressperson, but if we have to, we will. So we want to give you the chance to fix this before you have to deal with that. Another possibility is public pressure. This is a two-edged sword involving the media or going public in some way. There are times they can be very useful to create leverage. Sometimes it can backfire. And finally, there's litigation. On habeas grounds is a possibility. But there's also another creative possibility is under the Privacy Act. I've seen some interesting things being pursued there in a military context. And of course, also looking at litigation possibilities in other venues. But one of the problems with that is, of course, is that in most cases, you have to exhaust administrative remedies to get to be able to challenge things in litigation. There are some exceptions to that. The Privacy Act is one of the biggies. I'm happy to talk about that anytime. There's a lot of interesting possibilities in the Privacy Act in particular. But in most cases, the showing exhausting administrative remedies is one of the main problems. But I wanted to mention all those. You say we have a lot of tools in our toolbox. These are not, and none, in most cases, often my clients come to me and say, James, I'm thinking about filing an IG complaint. Should I do that? And very often we'll explore, like, well, is that really your right tool? And sometimes the answer is no. Let's pick up a different tool. But just having for them to be aware of the possibilities is a really useful thing. So I'm now going to hand it off to Aaron if you want to share a little bit, and then after that we will move on. We have just a few minutes before we need to move on to Jonathan. So let me get the mic where you can be closer to you, Aaron.
Thank you. Can everyone hear me?
Yes.
Well, yes, good. All right. My claim to such fame as I have in the area of Article 138 is that we are in the process. It hasn't gone up on our website yet, but we are in the process of revising an Article 138 article, which was written by Kathleen Gilberd about 10 years ago, and I did the revision. Since then, Kathy has been working on reviewing my revision to make sure that it's up to snuff. But we will soon have a version that's not 10 years out of date up on our website, and I can claim co-authorship for that revision because I based it on Kathy's work. That's what I've done besides my occasional foray into using the Uniform Code of Military Justice, Article 138, which appears, by the way, help me, Kathy, 10 USC section
938.
Beg your pardon?
938.
938. Write that down, folks. That's where you can find the Uniform Code of Military Justice in a congressional enactment. 10 USC, section 938. The Uniform Code of Military Justice is all enacted by Congress. Uniform Code of Military Justice, Article 138, is the article which says that a service member may complain to their commander. Of course, subject to, they first have to go through the process of making an informal complaint to the commander and up the chain of command toward the commander. But eventually, when that has not succeeded, if it has not succeeded, you can, as a service member, provided you are still actively a service member, file a UCMJ Article 138, naming the commander who either did something or failed to curb a subordinate from doing something which violates your rights, violates the fundamental fairness. There's a list of things that are in the service regulations. and I believe in the Department of Defense I'm sorry, the Department of Defense instruction that say essentially the same thing. If it is wrong, you can ask for an investigation, provided that it is not something that there is a provision for remedy in another part of the UCMJ or in the service regulations. The Air Force is most explicit in saying what you can't do in Article 138 about, but all the services have service regulations that exclude some things from Article 138. So if you are representing a service member, you should first off figure out whether you fall under Article 138 or whether the service member complaint falls under 138, because if you file something and it doesn't fall under 138, it will be dismissed by the command.
Yes.
So there are, besides the Department of Defense instruction, there are individual service regulations for each branch of the service. The Army has one, the Navy has one. I believe the Navy also covers the Marine Corps. And the Air Force, God help us, the Air Force has about 20 pages, which they recently issued a new version of.
Mhm.
In August 28th, I think, 2024. No big difference from the one they had before, but they figured it was time to put out a new version.
Mhm.
And the Air Force specifically says that their new version is to be read and that the old version should be disregarded. So
Well, this
you
is
got to read the regs,
Mhm.
the service regs, not just the DOD instruction.
Absolutely. Well, probably at this point, I need to transition now a couple things before we. One is for our next code for this hour is the letter B, B for Bravo. And I want to now introduce Jonathan Hutto, who will be closing us out today. And we'll, we have, so Jonathan, you're up.
All right, everyone can hear me?
Yes.
Okay, I'm trying to see what's going on with the video. That's all. While that's taking shape, we'll go ahead and get started. I'm looking at sharing a screen. First of all, Jonathan Hutto, Hutto. I don't know why you all can't see my video. Let's see what's going on. You all can't see.
Jonathan, you're now set up as a co-host, so you should be able to share on Zoom. Are you on your end? Are you able to do, like, if you play it on your computer? I think it should. You have to do the screen share thing. You have on Zoom.
Mhm. Yeah.
Either that, or if you want to send me a. Oh, good, you started it. Okay.
Mhm. Can y'all see my screen?
Yes.
Yep.
Okay, so basically, John Hutto, Hutto. Look, Navy veteran, 7 years, 7 months, 1 day in the United States Navy. So when we talk about grievances, and just give you a little bit about my background, when it comes to equal opportunity, I went to the Equal Opportunity Advisor twice during my enlistment on board the USS Theodore Roosevelt. Went to the EO twice, once on a belligerent fascist petty officer, E6. This was back in late 04, December 04, and then again off the coast of Iraq in January of 06. So what I'm going to do, I'm not going to go into the anecdotal aspects of this. I did that about a year ago via a forum that Kathy and I was on as well, along with James, and also what I may do is throw a link in here directly to a talk given at Gwen Mercy University about a year ago, where I went through the redress grievances aspect and some other things. So what I want to get into is what was learned through the process. So one of the things that, can you all see my face?
No.
But y'all can see what I got up here.
Yes.
Yep.
That's interesting. That's interesting. Y'all can't see my face. Well, I'm not that important. So anyway, the first thing is that the first thing has to be understood is that, you know, when you decide to go to equal opportunity as a service member, your career, for lack of a better framing within the military, is going to change forever. I use the word career, but rather loosely, because not just your career, it's your life. You know, it's going to impact you for the duration of your life. Your relationship to the military, your relationship to the colleagues you work with, just everything about you is going to change, because it's not just you going to equal opportunity to report a complaint of discrimination or harassment, what have you. What you're doing is you're taking on command authority. Okay. Equal opportunity within the military is there, but it's not really intended for you to use. Okay. And I found that out very early on. When I first went to equal opportunity, when I was very early in my career, everything was done within that process to discourage me from going. In fact, instead of me meeting with the senior chief equal opportunity specialist, I met with him once actually, but what ended up happening was the E9 master chief got involved. And then once the E6 made an apology for the discriminatory act, and in this case, it was myself being kept after work after a duty day when other people were allowed to go home. Okay. And I challenged that. Then now the gets to the point of retaliation. There's going to be retaliation. And usually what they're looking for is the first opportunity, because the command, your chain of command, operates in an arbitrary, as an arbitrary force, meaning that discipline is not equal across the board. They use discipline against those that they feel need to be disciplined. You know, so if you're someone within the command that they like, or someone who is, very, very, for like a better framing, you're someone that's locking step with the command, and you just happen to miss a duty day. That's not something that's going to get reported. Nor will you be really disciplined for it. They might chew your ass, for lack of a better framing, but you're not going to really get disciplined for it. But in my case, because I challenged the chain of command when I was coming back late for duty, because I was actually snowed in Washington, D.C. It wasn't because I was skipping duty. I could not actually get to the boat. In a situation like that, you're told that as long as you make a phone call and alert your chain of command ahead of time, especially conditions that can be documented, that you'll be taken care of. Well, that wasn't the case in my particular situation, and I got sent all the way up to all the way up to almost the captain's master, executive officer's inquiry, right? So that gets to a point that I'm making here. I'm gonna jump around a little bit about the fact that when you challenge your chain of command, how effective you are really depends on how much time you have within your chain of command, how deep your relationships are. It's not really based on the principles of equal opportunity itself. It's really based upon how strong of a sailor, Marine, soldier, airman you are, and how strong the relationships you have with the colleagues around you. Okay, I'm going to get to this. One of the things that they press very strongly within the Navy, and I'm sure it's throughout the services, is they push for you to handle your grievances at the lowest level possible. Always handle it at the lowest level possible. Go to the first person in your chain of command to raise your grievance, what have you. Now, of course, what they say outwardly is that this is about maintaining esprit de corps and what have you. Esprit de corps meaning cohesion, command effectiveness, etc. But that's not really what it's about. What it's about, that's what they say it's about. What it's really about is making sure that the oppression stays within the immediate chain of command. That it's not something that's ever addressed by the overall command structure. Captain, XO, executive officer, command master, chief, certainly not equal opportunity. So what you have to do is find a strategic way to engage that, to spark the overall chain of command, to actually dig into your particular shop to figure out what's going on. Okay, in this particular case, I had a hangman's noose dangling in front of my face off the coast of Iraq. Okay, and I had alerted my chain of command 6 months prior on what's called a brag sheet. Brag sheet, basically in the Navy, when you get ready to be evaluated, they give you what's called a brag sheet to brag on yourself, to say to the chain of command how great you are, right? This is why I'm so great. This is what I do. But there's a point in that brag sheet that asks you a question. I'm paraphrasing. If you could make strategic changes within your chain of command, what would it be? And so I used the opportunity to talk about the arbitrary use of discipline, the rampant racism, sexism, et cetera, within the chain of command, all types of stuff I talked about, right? That I felt would need to be highlighted. I felt need to be addressed, massive groping within the chain of command, misogynistic pictures on the back of the photo lab wall. I mean, you name it. And instead of the chain of command addressing my concerns, they told me that I was the concern. I was the problem. It's not the things you highlight. You're the problem, right? So 6 months later, now I got a noose in my face. So at that point, I'm trying to figure out, okay, how do I best try to get at this command structure? Okay, I'm going back to December 2004, where I went to equal opportunity and then got smacked down pretty hard. Was awarded extra military instruction by the executive officer. Okay, so now I'm trying to figure out how to do this. What I ended up doing was, in a clandestine fashion, sending a letter to my administrative department head, which I CC the command master chief on, and just I sent it to the entire chain of command with the exception of the captain, the executive officer. And what ended up happening was an equal opportunity investigation was sparked out of that immediately. Okay, make a long story short, the investigation it found it in my favor that these discriminatory acts happened. However, it put the onus specifically on the petty officer that pulled out the news. It did not hold my chain of command accountable at all, my immediate chain of command, for covering up for these folks. Worst of all, the senior chief who lied in the investigation, who stated that I never told him of these egregious acts and this desperate treatment when I told him about it 6 months prior, within the process of evaluation, right? So all that to say that that in the end, to get to James's point about the congressional aspect of this, your Congress member has no power at all to compel the chain of command to do anything. Let me just say that. Okay, I'm speaking from lived experience, so they have no power. And as organizers, that's what we're most concerned with, is how to build power. Okay, because you're dealing with a very powerful entity that has arbitrary power over your life, in every aspect, and they know it. To your liberty off a ship, to the amount of money you make, to the food you eat. They could throw you in the brig, put you on bread and water. I mean, they have total control over you. So what you're working to do is try to build some power. Once you totally have exhausted the equal opportunity process, then that's when you go to your Congress member. And the reason for going to your Congress member is really for one reason only, is really to put your case within the public sphere. See, what the military wants to do even though they are really against you going to equal opportunity, the equal opportunity advisors, and this is something that needs to be struggled against, the equal opportunity advisors are still within the chain of command. Let me tell you the kind of resistance that I had to really, how deeply I had to resist, because the equal opportunity, and this gets to James's point to some degree, like James says that he doesn't really like IG because you don't really get much from it. and I believe James when he says that. But what I would say to James, not so much to James, but just in response to James' statement, is that in comparison to the equal opportunity advisors, the IG is positioned better. I'm not saying it works effectively. I'm just saying the IG is not within the chain of command. Okay, the inspector generals are civilians. Okay, so technically they're supposed to be able to have some sort of autonomous function in relation to the chain of command. That's not the case with equal opportunity advisors. Okay, equal opportunity advisors, they are in the chain of command. These are senior chiefs in the Navy, senior chiefs, E7, E8s, E9s. They are responsible to the chain of command, and your chain of command knows this. So as we were going to the executive officer on this noose incident, this is the last step before going to captain's mast. As we were going to the executive officer, the same senior chief who told me that I was the racist, that's what I was told 6 months before the noose. You're the racist. No, it's not what you're talking about in the chain of command. You're the racist. The same senior chief was then demanding that I give him the noose before the executive officer's inquiry. I give him the noose. Okay. Why? Because in his mind, he's the power over me, so he can demand the noose. Now, what do you think he's going to do with the noose? Probably discard the noose. Okay. So what did I do? I disobeyed the order. Okay. I remember a boot camp. It was called the Nuremberg laws, right? I mean, I have a right to disobey unjust orders. So I disobeyed. And I took the noose and I put it on the executive officer's desk. And there's a reason why I had access to the executive officer's office, is because I was actually cranking at the time. Anybody know about cranking? I was going around cleaning officers' rooms, and I had the keys to their rooms. So I put the noose on his desk. That being stated, it's 2:52 right now. So I'm going to stop right here. I see there's some stuff in the chat. I don't know if those are questions. I think there's about 8 minutes left. So I'm going to stop right here, James. And if there's any questions for myself or Kathy, others, I didn't say as much as I could have said, but I shared as much as I would like to share, and I will go deeper with those that want to go deeper. Okay, thank you.
Thank you, Jonathan. And we do have a few more minutes left for questions. Our next session starts at 2 Central, so we got 8 minutes. So if you have any questions, comments, feel free to unmute yourself, and then we'll be getting the next session going at 2 o'clock Central. So if you have any questions, please go for it. Okay.
Yeah, I have a question. Okay, about Article 138, which for people in the Guard, we are told that unless you're under federal orders, it doesn't apply. And yet the law, the law passed by Congress says any member of the armed forces who believes himself wrong. So I'm just wondering, by what authority do the branches get to say, well, if you're in this category, it doesn't apply to you?
My thinking is that federal law trumps regulations. And so in such a situation, I would probably still make the complaint, but do so with an idea that this is leading to litigation. In other words, knowing that that would be the point of it, would be to challenge it. But yeah, I mean, from a practical standpoint, I think we can expect the branches to push back and to try to avoid. But I personally would say I would still submit it. One is that it's leverage. It can make them look pretty bad, frankly. So, but I mean, I think practically speaking, I would say that will it go anywhere? No, but I also am kind of hoping people will challenge that, because again, federal law trumps regulations, and the federal law is really clear on this point.
Recording in progress.
Well, while we're, sorry, I got me. Sorry, I'm trying to log into a second account because we have video. I can't run it on this machine, so it's giving me some problems. But I wanted to mention, though, that David Guestpass, who's going to be presenting in just a moment through a recording, he had asked that today, if there's possible for us to share a moment of a song, one of the songs from Barbara Dane, who was a very famous for her activism throughout her life as a musician, but especially for her famous FTA album that was published at the height of the coffee houses during the Vietnam War. So I'm going to pull up this and play this for a moment while we're getting geared up for our next hour block. But I really liked when David mentioned this, so I will get this queued up and we'll and then we'll be starting in about 4 minutes or so. Might be a time for a song or two while we're waiting. Actually, I realize I don't have the share sound on, so oh, there we go. Share screen. No, we need the sound on. Share screen. Share sound. There we go. We'll play this, and after that, we'll start our next session.
Situation the Army ever saw, was beaten by our officers and framed up by the law. Oh, join the GI movement, join the GI movement, join the GI movement, come and join the GI movement. We had to sign petitions and put up such a fight just to pass around a paper that contained the Bill of Rights. So join the GI movement, join the GI movement, join the GI movement, come and join the GI movement. If you won't be a killer, if you can't make that grade, you wind up sleeping on the floor down in the old stockade. Oh, join the GI movement, join the GI movement, join the GI movement, join the GI movement. I tried to read an article that was the Army's rule. The CO slapped me up and down and called me a goddamn fool. Join the GI movement, join the GI movement, join the GI movement, come and join the GI movement. I was raised in old Kentucky, Kentucky born and bred. But when I joined the movement, well, they called me a Chinese red. Oh, join the GI movement, join the GI movement, join the GI movement, come and join the GI movement. The generals ride fine horses, we walk in the mud. Their banner is the $sign and ours is striped in blood. Oh, join the GI movement, 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 come in, join the GI movement, join the GI movement, come in, join the GI movement.
So anyway, that was a little bit of the great late Barbara Dane. She passed away, I think, about a week or two ago, pretty recently. Yeah. But we wanted to honor her today with that song and just recognizing I have a lot of fond feelings for her because when I was involved with the coffee house we had for a time at Fort Hood, Under the Hood, we had one of her that album posted on the wall, the old record, and it was really an inspirational thing for us. So
I knew Barbara from when I was 16 and hitchhiked down to the Sea Island Festival. And there she was singing and playing.
wow.
Back in 1964.
In 64. Wow. Thank you so much, Aaron, for sharing that. Wow, that's incredible. Well,
Oh, she was a great woman.
She
was a great
was.
singer. She was a great human being.
Absolutely.